of the Joint Committee on the Judiciary. I'm joined by my Senate co-chair, Senator Brownsberger, to my right. At the far right, we have Representative Michael Day. To his left, Representative Paul Tucker. To his left, Representative Carol Fiola. And to the right of Senator Brownsberger, we have Ava Concepcion from the Senate Judiciary Committee. On the far left, Phil McLaughlin from House Judiciary Committee, Gretchen Bennett from the House Judiciary Committee, and Keith McFarland from the House Judiciary Committee as well. Today we have 65 bills before us today. We're in a packed house, so we are going to adhere to the clock. We have a 3-minute limit. I don't like to stop people when they're speaking, but I'm asking you to really please try and pay attention to the clock for the people who are waiting behind you. Oftentimes we have people who sit here all afternoon and maybe don't get a chance to testify because they have to leave for child care or work or something. So if you can pay attention to the clock, it is very respectful to all those who want to testify. And we want to make sure that everyone has a chance. And we will stay till the end regardless, but just ask for your help in that matter. As we go forward, we do, by way of committee rules, we do take electeds out of order because oftentimes there are other hearings going on in the building and we have to kind of be at 2 places at one time, so we do that. With that going forward, I think we are set to go. So we will call our first panel, which would be from the Governor's Office and the Executive Office of Public Safety, under Secretary Crowley, DA David Sullivan, and Woburn Police Chief Robert Ferrell.
Good afternoon. May I begin?
Sure.
Thank you. Good afternoon, Chairwoman Cronin, Chairman Brownsberger, and members of the Joint Committee on the Judiciary. Thank you for the opportunity to testify today in support of the Governor's legislation, House Bill 3655, an act relative to the harmful distribution of sexually explicit visual material. My name is Jennifer Quealy, and I am the Undersecretary for Law Enforcement at the Executive Office of Public Safety and Security. Prior to joining EOPS in 2015, I was a prosecutor and spent most of my career in the criminal courtrooms of the Commonwealth, where I prosecuted cases ranging from domestic assault and battery to sexual assault. In 2015, Governor Baker issued an executive order launching the Governor's Council to address sexual assault and domestic violence. The Council identified important changes to the laws governing how Massachusetts addresses the harmful distribution of sexually explicit visual materials by both adults and teenagers. The legislation that I am now testifying in support of today is largely a product of the Council's work and addresses 2 important aspects of the harmful distribution of visually explicit visual material, sexually explicit visual material. The first addresses juvenile offenders. Currently, minors can be charged with a felony, possession of child pornography, for peer-to-peer distribution of sexually explicit visual material. This charge is often too severe for cases involving minors engaged in sexting behavior and is clearly not what lawmakers had intended when they outlawed the distribution of child pornography. Indeed, sexting is a function of the ubiquitous use of cell phones by teenagers, a very recent development. This legislation includes the following important aspects. Creates a presumption that any child charged with distributing or possessing child pornography should be placed in an educational diversion program instead of entering the juvenile justice system. District attorneys and the Attorney General will retain prosecutorial discretion to use the juvenile justice process in appropriate cases. In those instances where appropriate, this legislation allows minors to be charged with a misdemeanor rather than a felony. Juveniles prosecuted for this new misdemeanor offense would be entitled to the same presumption that they should be diverted from the juvenile justice system. Schools would be required to provide age-appropriate education regarding the risks and harmful effects of the creation, possession, and distribution of sexually explicit visual depictions of minors as they relate to cyberbullying. Such education will promote prevention and early intervention and reduce the number of teenagers engaged in the harmful distribution of these sorts of images. As I mentioned earlier, I was a career prosecutor, and approximately 10 years ago, I was tasked with creating and implementing a pre-complaint juvenile diversion program in Middlesex County. One of the very first cases that was referred to the diversion program involved a 15-year-old girl who texted a nude photo of herself to her then 15-year-old boyfriend, who proceeded to forward the photo to his friends, one of whom blasted it out to numerous other students at their high school. It did not take long for virtually the entire school to receive a copy of this photograph. I can tell you that law enforcement, school officials, and parents were very grateful that we resolved the respective cases with diversion, where those most culpable were held accountable, but were not charged with child pornography, did not receive a juvenile record, and were not required to register as sex offenders. In addition to my role as Undersecretary at Public Safety, I'm also the mother of 4, with my oldest in her sophomore year of college. I am sure that all the parents in this room can attest to the effects technology has had on parenting. Treating juveniles with the presumption of age-appropriate diversion in these instances is a common sense and compassionate approach to this issue. The second aspect of the legislation addresses the harmful conduct widely known as revenge porn. Massachusetts law punishes non-consensual recording of sexually explicit images of unsuspecting people, but the law does not address the instance when an image is taken with the consent and then distributed without the consent with the intent to cause harm to that person. The harm suffered by the victim of this misconduct can be significant, and our laws should recognize the behavior. I've run out of time, so I just want to say that that over 30 states have taken similar action, and that the people of Massachusetts should have the same protections. Thank you very much for the opportunity to appear before all of you today and testify. Thank you.
Good afternoon, Chairman Brownsberger, Chairwoman Cronin, and members of the Joint Commission on the Judiciary. Thank you for the privilege of appearing before you today to briefly offer my support for the governor's legislation addressing the harmful distribution of sexually explicit visual material, House Bill 3655. My name is Robert Ferrell. I'm the police chief for the city of Woburn and appear today representing the Massachusetts major city police chiefs in the 40 cities that this organization represents. I'm in my 38th year with the Woburn Police Department and have focused the majority of my career on issues relating to juvenile justice and domestic violence. I have proudly served as chief of my department for almost 7 years, and over the last 18 months, I've had the privilege to serve with D.A. Sullivan on the Governor's Council to address sexual assault and domestic violence. This legislation will provide police officers additional tools in their toolbox to address the issues of distribution of inappropriate explicit material between their peers, and allow us to help manage the ever-changing use of technology by teens. Currently, our options are too limited to effectively use, and current diversion options are developed quite successfully on a case-to-case basis working with your local district attorney. Situations arise from time to time that it becomes very important to act in the best interest of the children involved. This piece of legislation will also give the district attorneys the ability to continue to proceed using juvenile justice should the totality of the circumstances require that action. A primary focus on education and prevention will hopefully provide the adolescent the knowledge to assist them in making the right decisions going forward in this area, and let them know that making the wrong decisions, again, they will be channeled into a more significant program and not made, and perhaps ultimately mainstreamed into the criminal justice system. This law does not address the instance where an image is taken with consent and then distributed without consent. This law does not address the instance where an image is taken with consent and then distributed without consent with the intent to cause harm to that person. The harm suffered by victims of this misconduct could be significant, and our law should recognize the serious consequences of this behavior. An aside, we had a situation in Middlesex County working with D.A. Marion Ryan, where we had a single individual in the 8th grade attempted harm to herself. We went and chased down a total of 50 cell phones that we recovered and worked through a diversion education program, taking it outside of the juvenile justice system. But the impact of situations like this with the child, with the children involved, is more than just the embarrassment of the image itself. Thank you for this opportunity to appear and testify before this committee, and I'm happy to answer any questions you may have.
Good afternoon, Chairman Brownsberger and Chairman Cronin and members of the Joint Judiciary. I have written testimony I'm going to submit later, so I don't want to repeat anything that both Under Secretary Crowley and the Chief repeated. But I just want to say that really there was a gap in the law, and it really was a child pornography law that was designed for adults and all the bad things, consequences that come from it. And so this is really to fill another part of what we need to do to address child safety and also accountability. And I, as a district attorney, and my fellow district attorneys have all endorsed this legislation, which I think is important, that we've been able to work with the governor's office and with chiefs and other constituents, children's rights and other constituencies, to make sure this is a balanced and sensible bill. And I think what will happen is, in our estimation, 99% of all the sexting cases will fall within diversion, which is a really good thing, that children won't be part of the juvenile justice system early on. They aren't going to have that blemish on their record, and they're going to have an educational component that's going to change behavior while also hold them accountable. And I think that's really a key to what we want. And we want children to learn from their mistakes, but to move on in a sensible way and to put that behind them. And also to make sure that the victim, that it could be a girl or a boy, that they know that somebody has been held accountable and that they also learn from their mistakes. But certainly the act itself of having their image disseminated in so many ways is harmful enough and punishment enough. So I think this is a good place for us to go. On the revenge porn, that dissemination, it's really important because there are intentional harmful acts that are done, and this isn't by a mistake. This is somebody who really, makes an effort to really hurt somebody. And I think that new category, which has been adopted by, I think, 38 states, really puts us at the vanguard and forward thinking, because as we looked at the legislation, and it was designed by the governor's office and others, it really wanted to respect First Amendment rights. So this is legislation that addresses the harm, but also at the same time respects First Amendment rights, that we're not infringing on people's rights there. And it also holds that accountability very high. And when it does happen, it's a terrible thing to happen to somebody. And whether it's an ex-spouse or ex-boyfriend or girlfriend, it really ripples through their entire lives, from workplace to their standing in the community. And it's something that we want to prevent, but also really hold the offender accountable. So I think that the way that this has been crafted, I think, is really a really opportune time to take care of this. I know on the way in with Undersecretary Quill, there was an editorial in the Herald today just on this point. And in fact, 10 minutes before I left the office, there was a sexting case that came in involving videotapes between minors. And we just don't want this to happen. And I think through education we can not only intervene, but we can prevent it.
Thank you very much.
Thank you.
Representative Roy?
Madam Chair, Mr. Chairman, members of this esteemed committee, thank you for the opportunity to testify. I'm here testifying in favor of House Bill 948. You heard some of the sentiment surrounding that bill with the last panel, but I just want to say I'm thrilled to be a part of a bipartisan effort to provide those additional tools for law enforcement and educational programming for teens that is part of a coordinated and holistic approach to address an increasingly prevalent behavior among teens. My introduction to sexting began with a phone call from Franklin Police Officer Jason Riley in 2014. He's unable to be with us today, but he has submitted written testimony, which I will supply with my testimony later on. But Jason was the school resource officer in town, and he was frustrated by the choices the current law provided to him to address sexting. Kids are not always aware that under current law, sexting may violate child pornography laws, which is a felony, and can require registration as a sex offender. Now, Officer Riley and his fellow officers turned to us as elected officials to provide options to address the issue that a changing society has given us. A few weeks later, the November 2014 issue of the Atlantic magazine arrived in my mailbox with a cover story on sexting. I'm supplying a copy of that with my written testimony. And that highlighted the collision course of mobile phones and indecent images. And that article introduced me to the great work being done by Elizabeth Englander of the Mark Center in Bridgewater and Amy Hassanoff, a professor at the University of Colorado, who wrote the book Sexting Panic. And both were instrumental in helping craft our bill. This bill was reported out favorably by this committee in the last session, and I hope you'll do the same this session. We know that these images can have lifelong consequences as we live in a world where nothing digital ever truly disappears. And you'll see some examples in the materials that I submit. If you think this is not an ongoing issue, well, the Washington Post did a very extensive article on teen sexting, which focused on a family in Auburn, Massachusetts. So the Washington Post doing a story on an Auburn, Massachusetts family that experienced this just last year. And a few months ago in the Boston Globe, there was, it happened in Duxbury, was the title of the article. I've included both of those in my materials. Now, but I'm happy to say that we're taking action. I filed my bill 948 in January, and the governor and the lieutenant governor, as you heard, they filed their bill in April. And these bills are direct responses to these concerns. So I'm suggesting that with the help of law enforcement officials, educators, academics, and parents, the legislation housed in H948 represents a coordinated effort and a holistic approach to address an increasingly prevalent behavior among teens. So just to note, in crafting that legislation, we consulted with individuals and advocacy groups, including district attorneys, the trial court department, particularly the juvenile court, defense attorneys, chiefs of police association, educators, a variety of juvenile advocacy groups, professors, the National Conference of State Legislatures, and others. So I hope you'll report this bill out favorably. And at this time, I'd like to introduce Denise Schulz, who is one of the commissioners for the Metro West Commission for the Status of Women. She's also a school committee member in Franklin, Massachusetts. The commission has made this bill a priority piece of legislation, and she will speak to that from the commission perspective and as an educator perspective.
Thank you. Good afternoon, Chair Brownsberger and Chair Cronin, and esteemed members of the committee. Thank you for the opportunity to present testimony today, and thank you, Representative Roy, for writing and championing this important legislation. My name is Denise Schulz, and I am a constituent of Representative Roy, residing in Franklin. I'm here today to present testimony in favor of H948, an act relative to transmitting indecent visual depictions by teens. I'm here in my role as the Legislative Director and Commissioner with the Metro West Commission on the Status of Women, and as a member of the Franklin School Committee. I came to testify today to let you know that the Metro West Commission has prioritized this piece of legislation as a priority bill because of the deep and damaging impact that sexting can cause, especially to young women and teenage girls. The Commission is charged with finding out the issues that impact women and girls in the Metro West region and advocating for policy that addresses these concerns and positively impacts their lives. The issue that Representative Roy is highlighting with this bill is complicated, but in research and advocacy, we have learned that sharing of indecent photos can quickly ruin the lives of young adults who are not fully comprehending the long-term effects of circulating indecent photographs of themselves with peers. As a school committee member and a parent of 2 teenagers, I would like to highlight the importance of curriculum. With limited time in health and wellness classes and insufficient access to current and up-to-date curriculums that include sexting and cyberbullying, our educators are left without the tools necessary to ensure that our teens are not participating in this risky behavior. This bill would work on creating a curriculum that can be distributed through the Department of Elementary and Secondary Education to schools in the Commonwealth to better educate and equip our students about the dangers of sharing these images, helping to alleviate a problem before it starts. In October of this year, our commission hosted a forum highlighting this very bill, and we heard from Senator Spilka about the negative impacts of teen sexting, and from Professor Englander, as Jeff mentioned, on how young adults are falling prey to this behavior, and they have a wholly different worldview than you or I might have on sharing photos amongst friends and the use of technology. We also heard from Franklin Police Officer Christopher Spillane, who shared his perspective as a school safety officer, and Officer Riley, who's unable to be here today, about this issue that originated in the, that we started in the Franklin Public Schools, and the tools that they use, or the lack of tools that they have access to address it. One of the most surprising takeaways for me was how clever the students are in hiding the behavior, and that they have this calculator app on their phones that stashes all of their nude photos in so that you wouldn't know even if you were checking it. We live in a society today where navigating media and technology is challenging, and can especially be challenging for rapidly developing teens who may not have proper access to proper media literacy. I believe this issue is disproportionately impacting young women and girls, and we need to pass this bill so that the law enforcement has a mechanism to diminish and stop the behavior by assessing appropriate punishments to those sharing the photos, and just as importantly, to promote and broaden access to tools to educate our young adults in risky behaviors and to protect themselves now and into the future. Thank you for listening to me, and I hope you report favorably on this bill.
Thank you very much, and thank you, Rep. Roy. I know you've been working on this issue for a long time and invested a lot of time and effort in it, so I appreciate your work. Does anyone have any questions? Thank you very much.
Thank you, Madam Chair.
And I'd also like to introduce on my far left, we're joined by Representative Sheila Harrington, who is the ranking minority member on the panel. And to her right, we have Representative Bud Williams. We've also been joined in the far end with Representative Dan Hunt as well. Next, could I have Representative Hogan and D.A. Ryan, please?
Good afternoon. I shall start, I guess.
Good afternoon.
Good afternoon, Chairs Brownsberger, Cronin, and to the committee. Thank you all for allowing me to testify today on behalf of my bill, House 2289, an act criminalizing sexual assault by fraud by a medical professional. A visit to the doctor is personal, private, and oftentimes just plain nerve-wracking. A patient in need of treatment and without medical knowledge will, out of necessity, rely on the representations made by a professional who is entrusted with the caring for them and for treating them. For this reason, patient-provider interactions must be held to the highest standard of professionalism. I was deeply troubled when D.A. Ryan informed me that she had been approached by individuals who had experienced sexual assault by a medical professional, and that there's a loophole in Massachusetts law that prevents her from prosecuting these perpetrators. The bill I introduced will update the state's sexual assault laws to enable authorities to prosecute a medical professional who sexually assaults their patient and tries to pass it off as being, quote, necessary for medical reasons. Individuals across the country are coming forward to report their experiences with sexual assault or harassment, illustrating the breadth of the problem sexual assault and harassment permeate, obviously, our society. As policymakers, it's our job to reflect on the imbalance of power that exists and to serve those in vulnerable situations. I believe that the medical field must be a part of this conversation. In this instance, we have the opportunity to say wrong is wrong. A medical professional should not be able to sexually assault a patient under the guise of medical care, and authorities should have the legal tools necessary to prosecute those that do. I want to thank Chairwoman Cronin, Chairman Brownsberger, and honorable members of the committee for your leadership. I respectfully urge a favorable report from the committee. I would also like to thank Middlesex County District DA Marion Ryan. She strives tirelessly to improve the safety and well-being of residents in our county and Commonwealth, and she's been working on this particular issue for a number of years. So thank you very much.
Thank you. Thank you, Chairman Brownsberger and Chairwoman Cronin. And I appreciate the opportunity to testify in support of Senate Bill 835, which is the same bill that Representative Hogan has just testified to, an act criminalizing sexual assault by fraud by a medical professional. I'm honored to be here together with the District Attorney for Middlesex County. I think the presence of both the Chief Law Enforcement Officer of the Commonwealth's largest county and, of course, Chairwoman Hogan, the House Chair of the Committee on Public Health, demonstrates the importance of this matter from the perspectives of both the criminal justice system and healthcare system. I concur with the comments of Representative Hogan on this important bill. And I think what the bill does and aims to do is to end the frustrations that victims feel, specifically by updating the sexual assault statutes to criminalize fraudulent representation and the necessity of proprietary conduct. And the issues of unwanted sexual touching have long plagued our society. They've been in the news quite a bit of late. But we don't expect, when one goes to see their physician or someone in the medical profession, to be victimized. I'm grateful that more people have begun to focus on this topic and regret the public pain that many victims feel. Those of us who are fortunate enough to work in legislative bodies have a moral obligation to close the loopholes in our sexual assault statutes that this bill aims to do. It represents common sense fix for this troubling problem. And the time has come to correct it as soon as we can, to send a strong message to the illegality of this behavior. Accordingly, I respectfully request that this bill and Chairwoman Hogan's receive a favorable report. And I want to thank you for your time and consideration. And again, I want to join Chairwoman Hogan in thanking District Attorney Marion Ryan for her outstanding hard work in this field.
Thank you. Thank you. Good afternoon, Chairperson Brownsberger, Chairwoman Cronin. As both Senator Donahue and Representative Hogan, who've been very helpful in getting the bill to this stage, have mentioned, this is an issue that I first saw over 20 years ago. It is a situation where someone goes to the doctor, they consent to touching. Their consent is really obtained by fraud because they believe either explicitly or implicitly that the touching is part of their treatment. So that then when they then learn later on, and it often happens when they go to another doctor or talk to someone else and realize that the touching that they experienced was what they believed it to be, inappropriate, and served no legitimate medical purpose. We then, when they come forward, they come to the police, they come to my office, we cannot prosecute that. And in this case, this would close that loophole because it would say that we would not be required, as we typically are in a sexual assault case, to prove the lack of consent or the use of force, because neither one of those is obviously present here. But it would, in a very small category of cases where medical providers get that consent through fraud, through a belief that it's necessary. And it is important to note that while probably the largest number of victims reporting this are women, we have also had a significant number of men who come forward and report the same, typically young men who report having been asked to engage in certain acts essentially because of their treatment. Very often, as part of recovery from some surgery, there will be a statement by the doctor, in order to see if you're recovering appropriately, I need to touch you in a certain way. You need to do a certain thing. And they comply with that, believing that to be part of the treatment. There are over 2 dozen states in the country that already have this kind of legislation. It is a common sense piece that should be reported out, and I would urge you to report out favorably to close that gap and offer protection to folks when they are treated in this way by their healthcare provider.
Thank you very much. Any questions?
Just one, Madam Chair, thank you. Thanks for bringing this in, and clearly, Senator said there's been quite a bit of news. Peter Ryan said one question. Is there a requirement in here that an independent medical professional gives you an opinion as prosecutor that it was not part of the course of treatment, or is it just an obvious indecent A and B that should not have been part of an examination?
That's a very good question. I think there are both situations. There are some where clearly what we hear, I went to the doctor for shoulder surgery and then he asked me to do something else. It's pretty clear and would be clear to a jury. I think we would not need expert testimony to determine that that was not necessary. There are cases where I think we would employ the use of an expert. For instance, certain kinds of semi-related surgeries or activities that might have happened, and then there's been touching in a certain way where you might need someone to come in and say, no, there's no need to have done that sort of thing.
Thank you.
Any questions? Thank you.
Thank you.
Thank you, Madam Chair. We have one more.
8:36.
Dear Brian, do you have another bill that you wanted to?
We do.
Yes, I have 3 others, one other with Senator Donahue.
There is one other bill, Senate Bill 836. This is an act relative to the crime of incest. With the committee's permission, I would give brief comments on this. I filed this bill together with District Attorney Marion Ryan, and again, I'm appreciative of her taking time out of her schedule to be here today. Currently, in cases of alleged incest with a victim younger than 16, the statute of limitations begins with the victim when the victim turns 16 or when the crime is reported to law enforcement, whichever occurs earlier. District attorneys like D.A. Ryan have found that victims of incest understandably hesitate to report an alleged crime while living with the family member who perpetrated it. And as a result, many victims turn to law enforcement only after they've left their childhood homes. And by that point, several years could have passed. The 10-year statute of limitations may have already passed, making prosecution difficult, if not impossible. And so what this bill does is it amends the statute of limitations for incest so that it begins when the victim turns 18, not 16, or when the crime is reported to law enforcement, again, whichever occurs sooner. I hope that you would agree that this is important for several reasons. One, young people reach the age of majority at 18, freeing them legally from their parents or guardians. 18-year-olds also usually achieve a degree of independence, whether they go off to college or on their own. And alleged perpetrators of incest should not avoid prosecution simply because of the nature of their crime diminishes the likelihood that victims will step forward immediately. So this bill reflects the reality that many young victims, what young victims face, and the odds of holding perpetrators accountable. So for these reasons, I would request that the bill be reported favorably.
Thank you. Thank you. And again, I would echo the comments of Senator Donahue. As you may recall, in 1996, the legislature began the process of changing the statute of limitations for sexual assault cases. For some reason, incest was not included in those changes. So those who are victims of incest, probably the most difficult crime to report of all sexual assaults, are actually secondly disadvantaged because they have all of the other dynamics to overcome. And unlike other victims for whom the statute begins to run at age 18, it begins to run, does not apply to victims of incest. So many times they are still living in the house, financially dependent, may not even have their own transportation. in an attempt to report that. So this change would move it to 18 when in all likelihood either they may have left the home and obtained employment or gone off to college. They would be free of those dynamics that may have prevented them from reporting, and it would give them the same advantage as other victims of sexual assault. I'd urge favorable action on that bill.
Thank you very much. Do we have any questions? Hearing none, thank you.
Thank you.
Representative Acero and Sheriff Katusian.
Madam Chairwoman, do you want me to address the other two bills that I have?
Would you want to just reference them?
I can do it quickly. Two bills. One is House Bill 3030, which is an act defining abuse and neglect. This applies to the statute requiring report to the Department of Children and Families of abuse and neglect of children. We all are familiar with that. We know about 51As. The problem with that statute is there is no definition of abuse or neglect. This would do three things. It would both give a definition for abuse and neglect, specifically accepting the regulations, the Massachusetts regulation definition for neglect, but DCF already uses it. It would provide that information to those who are mandated reporters. It would create a definition of abuse, including both physical and sexual abuse. It would also, and this is an important piece that is missing, right now if a report is made to DCF of abuse or neglect of a child, and the person perpetrating that abuse is not a caregiver, DCF is powerless to act. So this would change that definition to say that someone reporting to DCF abuse or neglect of a child by anyone, that DCF would be able to intervene, provide services, do what was appropriate under those circumstances. That's a gap that we should be closing. It also includes in what can be reported the kind of contact, sexual contact, verbal sexual contact with a child that is a part of the grooming that often goes on. So often before there's actual physical touching of a sexual nature, folks have engaged in things like electronic communication, the sending of photographs, that sort of thing, setting up meetings with children. It would make all of that reportable conduct as well. So I do urge favorable action on that bill. And finally, House Bill 942. This bill defines inducing a minor into prostitution. It is in response to a recent SJC case, Commonwealth versus Matos. Commonwealth versus Matos perhaps inadvertently created another category of victims, because what it said was that an individual who was being prosecuted for inducing a minor to prostitution could only be prosecuted if that minor had not previously been engaged in prostitution, because the wording of the statute was to become involved in become a prostitute. So if one were seeking to induce children into prostitution, one would then be wise to find someone who'd already engaged in prostitution, and then you could not be prosecuted. That clearly is not the intent of the statute. This would close that gap and protect those children who've already been disadvantaged because someone has already introduced them to prostitution. They should not be doubly victimized or become targets for predators who want to avoid prosecution themselves. So this would expand that definition as the SJC and Commonwealth versus Matos suggested the legislature should do. So it's a very simple, common sense fix, and I'd urge favorable action on that bill as well. Thank you.
Thank you very much.
Chairwoman Cronin, Chairman Brownsberger, members of the committee. I'm here today to testify on behalf of House Bill 706, an act regarding asset forfeiture, a bill I filed with our former colleague and current Middlesex Sheriff, Peter Katusian. This important public safety legislation would add crimes associated with child pornography and child enticement cases to our existing asset forfeiture laws, which have been instituted for crimes associated with controlled substances and human trafficking. The bill would enable state and county prosecutors to petition our courts for these assets if they were used in the commission of these serious crimes, and the individuals were subsequently convicted. Specifically, any item or asset used for the production, storage, or dissemination of child pornography or to entice minors would be cleansed and sold. The resultant funds would be used for internet safety education, victim rehabilitation and therapy, matching funds for federal grants to fund further investigation of these kinds of crimes, and the purchase of technical equipment for our law enforcement agencies. The National Center for Missing and Exploited Children estimates that 1 in 7 children will be subject to unwanted sexual solicitations online. As you know, this bill received a favorable recommendation from this committee last legislative session, and I hope you will find its merits of such action again this year, and I look forward to your decision. Thank you for your consideration, and with me I have Sheriff Peter Katusian, who's going to move forward with his testimony.
Madam Chairwoman, Mr. Chairman, members of the committee, great to be with you here today in support of House Bill 706 as filed by Representative Arciero. It's also supported, by the way, by the Mass Sheriff's Association as well. This is an idea that came to me when we had a cybercrime unit established through the Northeast Municipal Law Enforcement Council. It was something that we all committed resources to, and they were completely overwhelmed. So many cases were coming through regarding child enticement, child pornography. They were just completely overwhelmed. They didn't have the resources to address these matters. They didn't have the hardware to address these matters, and yet they were affecting families across Middlesex County and across the state. I realized that as a society, we knew there was a big problem, especially with digital issues in crime, but we weren't putting any of the resources available to those very crimes that we wanted to protect people from. We came up with this idea for asset forfeiture of those assets used in child enticement and child pornography. It's about educating, protecting children in our digital age, and allowing us to investigate. That was 3 minutes? That was really fast. I'm sorry. I thought it was going to be so short today. I really apologize. I'm going to go on very quickly then. I really apologize. Listen, the monies that would be realized through this would be used only on 3 narrowly devised initiatives. 1, digital literacy programs for youngsters, rehabilitation and therapy programs for victims, and law enforcement efforts to identify, catch, and prosecute child sexual predators. 1 in 3 children are exposed to unwanted sexual material. 1 in 25 receives an enticement to meet them. These are cases that are affecting our families, our neighborhoods, our communities, and yet we're not able to put the resources necessary available to be able to protect our children from these crimes. So we respectfully ask that you consider this much matching a few other states, and as well as much like the drug forfeiture law, but again, more narrowly tailored to address the very issue we seek to address through here.
Thank you very much. Any questions?
Thank you very much. Thank you, members.
Thank you. Now we have a comment by Senator Richard Ross. Mr. Flynn?
Good afternoon. Hi. Good afternoon, Madam Chair. Hi. Lisa Flint would like me to read her statement out to you so that you can all understand it. Her speech has changed over time, so it might be a little hard to understand.
Right. Sure.
Thank you, Your Madam Chair. Thank you, Madam Chair, Mr. Chair, other members of the committee. My name is Lisa Flint. I respectfully ask that the Protection of Persons with Disabilities Bill, or what we prefer to call it, Lisa's Law, be adopted and made into law. The point of this bill is to remove the cap on criminal sentences for those people who are convicted of sexually assaulting physically handicapped persons. Currently, laws like this exist, but only for the benefit of those who are mentally handicapped. This is understandable since the individuals may not always understand what is happening to them, but we need protection too. Many of you may know my story, as I and Representative Poirier have been working on this law for years. But for those of you who do not know or who cannot remember, I was raped on Mother's Day of 2000 in my college dorm room. I was fully aware of what happened to me that night, and even more importantly, I was fully aware of how vulnerable I was because of my inability to stop him. He preyed on me because he knew I was unable to do anything to stop him. He preyed on me because of my disability. Thankfully, the rapist was caught, but my relief was quickly subsided when the prosecution process started. Luckily, I worked with the best witness advocate and ADA I could ask for. They made this trying ordeal somewhat manageable. The toughest part of the trial was when I had to testify against him, but I did it, because I was not going to let him get away with what he did to me. And then it came, the conviction. Finally, after what seemed like a lifetime, a jury of his peers decided he was guilty. Then came sentencing. Under Massachusetts law, the rapist sentence was capped at 20 years, because the law does not distinguish me from a fully functioning person. This law likens me and many others to people who are nothing like us. I have cerebral palsy. I'm not able to protect myself, or feed myself, or even take myself to the bathroom without assistance. However, I am brutally aware of everything that goes around me, and my lack of ability to do anything to stop it. I'm asking the committee today to help me change this gap in the law. I believe that physically handicapped people deserve equal protection under the law as mentally handicapped people, because we are targets of these crimes too. Just because we understand the crimes that are being perpetrated against us does not mean we are capable of stopping or preventing them. In the time that I have been fighting to make this bill a law, the rapist was released from prison. He was released October of last year. He was not out even a year before he was in violation of his probation. And he's still out. This scares me because every day that passes, I wonder if he will come back, and what will I do then? The older I grow, the weaker and more spastic my body gets. In the years this bill has been proposed for legislation, my speech has become greatly impaired, so much so that most of you would not understand me. I'm constantly in pain from my disability, and other related medical problems must consistently be monitored. To know all this, and to know that someone who raped me years ago is free, is like living in the nightmare again. I understand that this bill will not be retroactive. I am doing this to protect others, because if this were to become a law, the next physically disabled person who is raped will have a peace of mind to know that their convicted offender will never do this to them again. It is a peace of mind I will never have. Thank you for your time and consideration. I truly appreciate all who have worked so hard to make this bill come to life. Please continue to pass this bill along so it may become law. Thank you, Lisa Flint.
Thank you very much for coming. We appreciate it and for sharing a very difficult story with us. Thank you. Thank you very much. Senator Lovely.
Thank you, Madam Chairwoman, Mr. Chairman, members of the committee. For the record, Joan Lovely, State Senator for the 2nd Essex District. I write to offer my strong support for Senate Number 902, an act amending the statute of limitations regarding criminal prosecutions for the crime of sexual assault and rape of a child. As a sponsor of this legislation, I support practical and effective measures that we can take as a Commonwealth to address and prevent sexual abuse of children. According to a study conducted by the Center for Disease Control, 16% of men and 25% of women have experienced unwanted sexual contact with an adult or older child when they were children. Additional studies show that 1 in 4 females and 1 in 6 males report having experienced some form of sexual abuse or exploitation before the age of 18. Yet it is estimated that 80% or more of child sexual abuse cases are never reported to law enforcement or child protective services. This legislation would ensure that survivors of sexual exploitation or abuse are able to file a complaint alleging an offense at any time after the commission of such offense, provided that the victim was under the age of 18 when the offense was committed. It is imperative that we as legislators take every step possible to protect the children of the Commonwealth. This bill takes important steps to ensure that those children who are survivors get the help and support they need at any point in their lives. I therefore reiterate my support for Senate 902. Thank you. Happy to answer any questions.
Thank you. Any questions? No. Thank you very much.
Thank you.
Representative Khan?
I'll sit back. Do you want to sit here first? I'll just stand up. Okay, thank you very much, Chairwoman Cronin and Chairman Brownsberger, and to the committee. Thank you for allowing us to testify on House 3499, an act decriminalizing prostitution. So I'm here in support of this piece of legislation. It's been one of my priorities, and it's the issue of commercial sexual exploitation. And I hope to build on successful efforts that we've made in the past. Massachusetts, we did pass a human trafficking statute in 2011, and I think we can do more, and so we're here to talk about some of the things that would be important for us to think about and to have beginning conversation. So I'm going to cede my time to these four ladies here who are really the experts, and I think Kate, we thought we would start with Kate. If you could just introduce yourselves and tell us why you're here, that would be great. Thank you.
Should I do my testimony as well?
Sorry?
Or should I just introduce myself?
Yes, yes.
Okay. So my name is Kate Price. I am a third-year PhD candidate at UMass Boston. I'm a policy expert in the commercial sexual exploitation of children. I am also a child sex trafficking survivor, and I also come today as a constituent as well. Should I do my... Okay, all right. So thank you, Chairwoman Cronin, Chairman Brownsberger, and Representative Khan for writing this bill, as well as the entire committee members. So I testify today in three capacities: as a policy expert in the commercial sexual exploitation of children, or also called a CSEC, as a CSEC survivor, specifically of family-controlled child sex trafficking and child pornography, as well as a constituent, particularly because Senator Cream, who's on this committee, she is, and I'm a Wellesley resident. So as a policy expert, I support this bill because arresting and prosecuting sex-trafficked minors fails to consider arrest and incarceration re-traumatizes CSEC victims. Up to 90% of CSEC victims have histories of sexual abuse and physical and/or emotional neglect prior to exploitation. Suffolk County District Attorney Dan Connolly has stated on the record that his office is committed to not prosecuting sex-trafficked minors in order to, quote, protect her and put her in a safe and healthy track, unquote. However, this statement fails to consider how being arrested is re-traumatizing in and of itself. Additionally, anecdotal evidence suggests that state prosecutors demanded Massachusetts human trafficking law retain the right to arrest and prosecute CSEC minors and to be able to threaten them with arrest and/or prosecution in order to control, quote-unquote, non-compliant sex trafficked minors. Again, this argument fails to consider the very act of arrest can trigger traumatic responses, such as appearing, quote-unquote, out of control. It's no surprise that the majority of the 14 children who have been arrested for prostitution in Massachusetts since 2014 were girls, and most are children of color, particularly African-American children. A study examining trauma and CSEC victims found that girls and all children of color, particularly African-American children, boys and girls, in this sample had the highest rates of child sexual abuse and neglect prior to exploitation. While this study didn't examine the traumatic responses of CSEC victims in being arrested, these findings suggest that girls and all children of color, particularly African-American children, have the most risk for being triggered by having triggered traumatic responses when they're being arrested, since they have the highest rates of childhood victimization in this population. My own gender-based research is data-driven, and it's in CSEC policy, its research is survivor-led. My perspective as a CSEC survivor is important because I personally experienced the discrimination and the disregard for my own overall health and well-being. While I was never arrested for prostitution, I was definitely considered disposable by my family and my community, who continually looked the other way even though they knew I was being victimized. Therefore, I am here today to use my voice as a CSEC survivor and as a policy expert to ensure that CSEC victims are protected and supported by receiving trauma-informed services and care and not being criminalized. Thank you.
Thank you very much.
Madam Chair and Mr. Chair, thank you very much for this opportunity to testify before you in support of House Bill 3499. Commercial sexual exploitation, primarily of women and children, has become a global business, reaping enormous profits for pimps, traffickers, and their intermediaries. I would say from my own work, experience in directing the International Coalition Against Trafficking in Women for 13 years, that we have reached a point in this country where we are facing what is really a public policy crisis caused by a flourishing commercial sex industry which is operating with almost impunity. One of the provisions of Representative Khan's bill is on sex buyers. And this is a very important link in the chain of trafficking and sexual exploitation. Sex buyers contribute the funds that support pimps and that support organized crime. The most invisible actor in this business of commercial sexual exploitation has been the sex buyer. Massachusetts took the first step in penalizing sex buyers when it passed its anti-trafficking bill in 2011. But after the law was passed, sex buyers were seldom arrested for a variety of reasons. For survivors of sexual exploitation who worked hard for these kinds of laws, it has been very discouraging that the laws are not being enforced. House Bill 3499 gives us a new tool with which to battle sexual exploitation. Its definition clearly describes the reality of commercial sexual exploitation and specifies penalties for sex buyers. A comprehensive study in the United States reviewing all initiatives against sexual exploitation in the country found that penalizing the buyers is the most useful measure in fighting commercial sexual exploitation. It also discovered that police are led to other crimes such as money laundering. In passing this law, Massachusetts would join other states that have similar legislation. For example, New York. New York has also added special courts to try cases of commercial sexual exploitation. There are many European countries such as Sweden, Norway, Iceland, France, the Republic of Ireland, Northern Ireland, that have also passed anti-demand legislation. Originally, the Swedish police were opposed to such a law, and it is common knowledge with organizations working on such legislation that police departments are often opposed to these laws. But now police report that because the law has had a chilling effect not only on sex buyers but also on pimps and traffickers in Sweden, the police report that it makes it less appealing for pimps and traffickers to set up shop. So in closing, I would say that many states are coming to recognize that women and children in prostitution are the victims, and those who purchase the bodies of women and children are the perpetrators. This bill acknowledges that it is nearly impossible to combat commercial sexual exploitation without penalizing the demand, because without demand there is no supply. Thank you very much.
Hi, I'm sorry. Hi. Right. Sorry about that. Hi, my name is Nicole Bell. Thank you to the chairs and the committee for giving me the opportunity to give testimony on behalf of Bill H3499. My name is Nicole, and I run an organization called Living in Freedom, a survivor-led nonprofit agency whose mission is to provide resources, advocacy, and support to survivors of prostitution. And I myself am a survivor of trafficking as a teen and the commercial sex industry as an adult. Historically, our approach has been arresting victims to address prostitution in our communities. We are saying that we recognize individuals involved in the commercial sex industry as victims, yet we are arresting and incarcerating these victims
at a rate 10 times higher than those that fuel the commercial sex industry, the buyers. We are arresting and charging victims, yet the men who pay to sexually assault these victims have gone largely unaffected and unscathed. As inappropriate and unfair as it has been equally ineffective in reducing prostitution in our communities. 132 individuals have been served at the Lift Drop-In Center, which is a safe place for women involved in street-level prostitution in the city of Worcester. Over 60% of these women had said that they had been arrested, and when asked how many times, all of them had replied more times than they could count. So I think this shatters the notion of that we're arresting these women to help them or keep them safe, because of this 60% of the 132, all of them are still involved in street-level prostitution and have been arrested more times than they can count. And though arrested more times than they can count, they're still being exploited on the street. These same arrests then become barriers to exiting the commercial sex industry. These arrests follow these women while they're trying to attain housing and employment. I remember how re-victimizing it was to have to explain my prostitution charges to a potential landlord. Just imagine for a minute sitting across from a potential employer or landlord, and typically a white man with disposable income of power, and having to explain your 15 prostitution charges to these men. You know, I don't have to imagine that, I lived that, and I can tell you it's traumatizing, re-victimizing, and simply not right. And I'm certain that if I wasn't doing the work that I do today, that I wouldn't have any work, because my criminal record would prohibit that. You know, if I did, like I said, if I wasn't doing the work that I was doing today, my prostitution convictions would leave me without an income, without work, and forcing me back into the system of prostitution, a place I pray I never have to return to. We have seen this type of legislation drastically reduce prostitution, which clearly arresting the victims have not. As long as we continue to ignore demand or the purchaser, we'll continue to see gender-based violence rampant in our community. I support Bill H3499 in order to decriminalize for the commercially sexually exploited person, increasing fines and penalties for purchasers, and will continue to personally work towards providing valuable exit strategies for victims and survivors. We can improve the lives of the survivors of the commercial sex industry who feel that due to their criminal record have no other options. Survivors like the women I work with who want nothing more than a way out. Women like myself. Thank you.
Thank you. Is that loud enough? I am Maureen Norton-Hawk. I'm a professor at Suffolk University. I teach courses on international drug control, national drug policy, and classes on women in corrections. I have been conducting research on street prostitution for more than 20 years, and it started with a study that was commissioned by the Boston Police Department to study street prostitution. I would like to thank Representative Khan and the Judiciary Committee for allowing me to testify. I support the bill in addition to the victimization of women and children and men and just victims of commercialized sexual exploitation for 4 reasons. It's an inconsistent law in practice and what's on the books. There's an inconsistency in what we're doing with the law and how it's enacted. The cost of incarceration is ridiculous. We are spending way too much money that would be better spent providing services for victims. Incarceration, as mentioned, is ineffective, and 4th, it's counterproductive. It actually makes the situation much worse for the victims. I don't know if you got a copy. I'm going to be working with a couple of charts. Okay, so I'm going to be referring to a chart on page 3, which indicates that it shows from 2004 to 2013 the number of convictions and incarceration. And as you can see, informally, we are not convicting and we're not incarcerating at the same rate that we were before, while the bill is still on, the law is still on the book. So it makes no logical sense to continue doing what we're not doing. Below that is the incarceration rate. Once, in fact, you get arrested and convicted, you're equally likely to go and spend time in jail than as it was in 2004. The next chart looks at the cost. One of the things that I did was to look at the cost per day, per number of days that women and men spent in prison for a prostitution-related offense. And as you can see, we had over 1,200 convicted in those 4 years, and those that were incarcerated was a little bit less than 500. If you look at the next page, we're talking about $4.1 million for incarceration. And if you figure out the number of days by the annual, the daily rate per inmate. If you look just at females, females are 85% of those who are incarcerated. We're now talking about just about $1 million a year. It does not make any sense. As mentioned before, this law that against prostitution for the victim doesn't make any sense because it is ineffective. In a study of 125 women that were incarcerated in released from MCI Framingham in 1995, of those who were arrested for moral charges, 57.6% were reincarcerated for a drug or a prostitution offense. The last one you can probably read for yourself. It's just a list that how it actually makes the situation worse. It's a survival straight. I probably interviewed more than 500 women who have worked on the street, who have been exploited on the street. I have met maybe 2 that said I'm doing it for fun. It's a choice, but it's a constrained choice. They do it because of the drugs, because somebody's forcing them to do it. I'm hoping that you will consider adopting House Bill 3499, and act decriminalizing prostitution. Thank you.
Thank you very much, Representative Iowa.
Thank you, Madam Chair, and for your testimony, and to Chair Cronin as well. Of the 500 women that you interviewed, 2 did it for fun.
Yeah, or they said they enjoyed it.
Of the 498, what percentage of those do you think had substance use disorder issues?
Well, I would say probably 90%. I mean, it is just, even in my most recent study when I was over at the House of Correction, many of the women never get arrested for prostitution. But when you ask them, have you ever, oh yeah, I mean, this is something that you do that's associated with drugs. I mean, you do what you have to do to avoid being dope sick. And with the opiate epidemic, this is, has become very, very common pattern. And, by putting them in jail, it doesn't make any logical sense. I can think of a lot of things that we could do with that $1 million in terms of providing help for victims.
Thank you, Chair.
Thank you. Any further questions? Thank you very much. Sana Fidel, Reverend Mariana Hammond, and Bill Camden.
Good afternoon, Chairwoman Cronin, Chairman Brownsberger, members of the committee. My name is Senna Fadl. I'm the Deputy Director at Citizens for Juvenile Justice. I'm here representing a statewide juvenile justice coalition with over 50 organizations across the state who are members. We are here to testify on behalf of House Bill 3065. We want to talk about teenagers engaging in sexual activity. Sexuality and sexual identity development are a normal part of adolescent development. In Massachusetts, 36% of high school students self-report engaging in sexual intercourse. We know many more engage in other forms of sexual touching. In Massachusetts, if any of those are under age 16, they are committing rape or indecent assault, depending on the behavior. What House 3065 does is allows Massachusetts to come into line with the majority of states in this country. Only 3 states, including Massachusetts, do not have what's called a peer exception, recognizing that addressing teenage sexuality through the criminal justice system is not the best way of addressing it. Massachusetts law does not carve out this peer exception, and that encroaches on the role of parents. the faith community, and health and public health practitioners. The role of these laws is to protect young people, and by saying that that the first response is if anyone is under a certain age, and that is the crime, and not taking into account that it's consensual and our peers, that the other person is also a child or a teenager. We're saying because of the charges, it becomes a lot of young people say, well, I can't really talk to you because are you going to report me? A school nurse or a pediatrician can't talk to, well, if you talk to me, like, what is my role? Do I need to report it? There's a lot of things where we want young people to be protected. How can you, if I want my child to be able to talk to their pediatrician, to my clergy member, to members in the school, someone who is a trusted adult to say, this is what's happening. How can I be safe? How can I be healthy? And if we know that there is this threat of prosecution, it actually stifles that conversation, allowing my child to be able to talk to a trusted adult. We also looked at arrest data of who gets arrested, children who get arrested for these charges. In 2016, 35 children and teens, some as young as 11, were charged as these rapists and sexual assaulters. And in my written testimony, I'll provide a breakdown of the numbers, but it's 35 from a broad range of cities and towns. I do not have Boston and Lawrence data, which does not have arrest data. I cannot tell you, because yes, you know, we don't have the data, I can't tell you who gets arraigned, what happens, who gets what happens. But if someone does get prosecuted, you have the threat of being put in a sex offender registry, incarceration, a lot of more long-term impacts on young people. Thank you.
Good afternoon. My name is Reverend Mariama White Hammond. I currently serve as the youth pastor for Bethel AME Church in Boston. And I spent the weekend helping 7-year-olds learn how to tie Christmas bows for the first time. And today I sent care packages to our high schoolers, or our college students as they're preparing for exams. I love all of our children. I consider it a privilege to watch them grow from babies into adults. And my favorite group is the teens, and in youth group sessions and in one-on-one conversations, I see them questioning who they are and who they want to become. They are negotiating their own identities and relationships with their parents, their friends, their teachers, and the people that they are attracted to. How do I know if I'm in love? How can I tell if someone loves me? Am I ready to have sex? These are key questions that many of our young people struggle with. And I encourage them to wait. But statistics and my experience with my own peer group lead me to know that many of them will not make that decision. Some of them will choose to have sex in their teen years. And sometimes they will feel good about the decision, and other times they will find that the experience is not what they thought it would be. And I have certainly had to pray with young people who regret the decision to be sexually active, and I have counseled parents who are hurt or angry when they find out that their child has chosen to have sex. They may lash out at their own child, and often they are angry with the person that their child is having sex with. I've been in this tough situation, and I am confident in my ability to help families negotiate this conversation. I am here in support of House Bill 3065 because I believe we should keep those conversations about consensual teen sex to be negotiated by faith leaders, youth workers, counselors, or therapists, rather than by the criminal justice system. If children have been violated in any way, or if there is a case of an assault, then I think people should be prosecuted, but to the highest extent of the law. But I should not have to worry about reporting teenagers who I know have chosen to have consensual sex. And I am deeply concerned about the fact that the young men, and particularly young men of color, are disproportionately prosecuted in these cases because the execution of the law is not equally enforced. If we think about it, many of us know people who should have gone to jail under this law, but certainly didn't because it was normal in high school for people to choose to have sex with each other. As a woman who has experienced sexual assault as a young person and who has counseled many young people, mostly female but also male, who have been assaulted, I don't think we should ever blur the lines between consensual and unconsensual sex. 47 other states have addressed this issue by passing similar bills, and it is time for Massachusetts to catch up with its sister states. I count myself among one of those peoples that hope we can reduce teen sexual activity, but making it a crime is not the way.
Good afternoon, Chairwoman Cronin,
Chairman Brownsberger, esteemed members of the committee. I'm here to talk in support of House Bill 3065. And I have a very different perspective in that I work for the Criminal Justice Policy Coalition in Boston. One of the things that I do is help sex offenders transition back into society, primarily in Boston, I might add. And I have seen personally the effects of consensual juvenile sex turning into a criminal conviction that a person will carry for at least 20 years, perhaps the rest of their lives. It seems only right that we find a way to realize that those things happen and they're not necessarily criminal. The victim, perhaps, if you will, is underage and unable to consent. Those things happen in high school. We all know that. So there has to be an equitable way to protect kids and encourage them not to have sex in high school, and then find a way to not strap somebody for a bad decision the rest of their lives. So I think that the time has come, as the Reverend just mentioned, for us to get on board with the changes in our society and to recognize that those situations do occur and that it's unfair to punish somebody for a long, long time for an indiscriminate or indiscreet juvenile act. I thank you very much.
Thank you. Any questions? Thank you very much. Representative Ferrell.
Thank you, Madam Chair, Chair Brownsberger, committee members. Thanks for taking me out of order and for listening to my testimony today. I have signed on as a co-sponsor of House 3065, although with mixed feelings, and also onto 3 other bills about which I feel far less strongly. But I absolutely agree with the prior panel about the importance of not requiring young people to have a lifelong legacy of having to be a registered sex offender, of being involved with the criminal justice system, necessarily because of their sexual explorations at a young age. At the same time, as a mother and as a woman and as someone who hears a lot of sad stories, I'm concerned about going from the abolition of the crime of statutory rape to nothing whatsoever. And I've been thinking long and hard about what could be in that place. But knowing the power imbalances between young people and how sometimes more sophisticated or sometimes even manipulative young people can take advantage of others, whether it's because of gender disparities or simply less sophistication, or a greater desire to be socially accepted. I think that the roots of some very bad behaviors are evident in the power relationships that develop among young people. I don't know the extent to which there might be a way to get the probate and family courts involved in sorting out some of these complaints, because I do think we want to stop manipulative and exploitative and assaultive behavior whenever it's manifest. But at the same time, I completely concur with those who don't want to see young people saddled with criminal records, and especially having to belong to sign up in a sex offender registry for the rest of their lives. because they were indiscreet or they sent photographs of themselves or some of the foolish things that young people do. And I thank you for listening to these rather incomplete thoughts.
Thank you. Representative Tucker.
Thank you, Dr. Lopez. I just want to see if I'm on the same page, which I think I am. I was actually going to ask the previous panel, but I didn't, because I gave some more thought. I don't necessarily disagree with a lot of what the previous panel said, except that I believe that they made an assumption that it was a clear balance, 50-50 consensual, and not getting the police involved. I don't necessarily disagree that the faith community doesn't have a role. I think they do. Family clearly has a role. When we start with the assumption that it's a perfect balance of power between the two, and we make that assumption and law enforcement never gets involved, how do we know if that's the correct starting point? We're on the same page?
Yes, that's what I've been wrestling with, because if we give up the possibility of having certain behaviors, at least categorized as criminal actions, and I don't know if the law of assault provides a good alternative, but I think that these situations are very fact-specific and that the power dynamics are important. And, in the world of healthcare law, we put a lot of emphasis on the concept of informed consent to medical treatment. And I struggle a bit with the idea of giving young people who are too young to consent to medical treatment, imbuing them with the authority autonomously to consent to sexual activity. I even think it's an anomaly in our law that a young woman who at 16 is too young to consent to her own abortion without the permission of an adult is considered young enough to consent to sexual intercourse, when it could end up being she's not just consenting to intercourse, she's consenting to motherhood. And I have a lot of confidence in your committee, and I just wanted to share my thoughts with you because I'm very torn between what I think are important social values of decriminalizing a lot of youthful sexual activity, but reserving somehow an ability to look at that behavior and to correct behaviors that are malicious and harmful and which do violate the will of the other party.
Thank you. I shared your thoughts, and as I said, I think that the previous panel made some excellent points, some fair points, but I'm just concerned about that imbalance and beginning with the assumption that this is somehow an equal participation.
If I could follow up, there was a situation in my community where there have been situations where disabled teenagers have had have been drawn into sexual behavior, and you have to consider whether they even if non-disabled young people of the same age are able to consent knowingly, whether young people with intellectual or physical disabilities are necessarily able to consent, and there is the possibility that even young people who think they're consenting are in unwholesome relationships or terrible home situations where their thinking is not clear and they're looking to escape, or they're looking for some some kind of love that they're not getting at home. And I don't know that we can turn our backs on them. I think we have to have something to offer them, even as we move toward being more reasonable about some of the behavior, which we now criminalize in a major way.
Thank you. Representative Harrington?
Thank you. And I share a little bit of confusion as the representative from Salem had. I guess what I'm more concerned with is Section 2. So I understand the whole concept of wanting to realize its children and involved and keep it out of the criminal courts if possible. But if I was to read this correctly, for instance, the last disqualifier on sexual intercourse or unnatural sexual intercourse with a minor under 16. If, for instance, the minor is under 12 years of age and the defendant is more than 2 years older, so if you had an 11-year-old and a 14-year-old, for instance, it would be punishable by imprisonment in state prison for life or another term of years. So what I don't understand is that you can still have where consent can't really be given legally until you're an adult, truthfully. So none of them can really be consensual. I share the concern on, I guess, a different issue as to how that would ever be played out. Because you wouldn't want to see a 13-and-a-half-year-old go to prison for life where up above you're only going to be dealt with in the juvenile court system. Okay, so there seems like a little bit of disparity in punishment.
I think there are disparities, and when you go to the extreme cases, it becomes very troubling. You know, over this long weekend, I encountered the family of a constituent where the young man was charged the week after he turned 18 with a sex crime. The charges were dropped. The charges were dropped, but he could not go to school. He could not be tutored. You know, he applied to a number of colleges. Most simply did not reply at all, and those charges were dropped. You know, this is a life-altering stigma that we place on young people, and I think we've got to do something about that. But at the same time, you know, young teens and even older teens are not, they're not completely cooked. Their judgment is erratic often, and they vary a lot as to their social maturity. And you know, if we can't be supervising all of the time, we need to be thinking about protecting them from even their peers, if their peers are malicious or predatory or taking advantage of them.
All set. Thank you.
Thanks very much.
We're also joined on the left by Representative Jim Campbell. Representative O'Connell?
Thank you very much. Thank you, Madam Chair, Mr. Chair, for taking me out of order, and members of the committee. Thank you for the opportunity to testify. I have several bills before you today, but I'm just going to concentrate on House 919, an act relative to public access to sex offender information. What this bill does, it allows public access to sex offender information upon request at the local police department. To access this information, you must go personally, ask for it. You must have a specific name or address that you're asking about. You cannot simply go and say, give me a list of all level 1 sex offenders. And we started this conversation about 5 years ago after the horrific Burbine case in Wakefield that I'm sure many of you remember. John Burbine, who was a level 1 sex offender who had been convicted of raping children, was registered as level 1. And in Wakefield, his wife owned a daycare center. He had access to children. And he was, in 2012, convicted of over 100 counts of just heinous crimes against infants and children. And at that time, there was, of course, outrage. There was calls for action. There was a lot of discussion around this issue. And we learned a lot of facts that I think many of us were unaware of. Specifically to Wakefield, we learned that 16 out of the 17 registered sex offenders that were level 1s had committed their crimes against children. And no one had access to that information. We also learned at that time that 65% of all level 1 sex offenders in Massachusetts had committed their crimes against children. And you know, as a mother of two myself, I know many, if not all of you, are parents. It's hard to imagine the trauma and the heartache and the horror that the parents and their children went through over this case, and that they still go through. And in particular, a mom who went to the police station because she had a bad feeling about John Burbine, and she asked for information on whether he was a sex offender, and they could not give her that information. And then this case happened, and we learned that through the newspaper and through Chief Smith. So today, 5 years later, we still have not taken any action on this issue, and we know that not much has changed. We know that right now, level 1 sex offenders, for all the crimes for which you can be required to register as a sex offender, level 1 sex offenders have committed all those crimes except 4 on that list. So that means that they have committed virtually every crime that a level 2 and a level 3 sex offender has committed and are on the registry for. And those include rape of a child, dissemination of child pornography, and other heinous crimes. So I think the unfortunate thing is memories seem to have faded, outrage has subsided, and we still have not dealt with this issue, even though we have had several opportunities to. Senator Clark at the time in 2013, 2014 filed legislation that was included in a bill, but then unfortunately was kicked out in a conference committee. I've brought this to the floor several times, was actually very fortunate to get it passed in the budget this year in a different version. However, that was kicked out in conference committee. So it has led people to question the will of the legislature, including Chief Smith of Wakefield, who I've been speaking with about this. And I'm sure some of you may have spoken with him. I know my time's up, but he wanted to be here today. Unfortunately, he could not be here. So he submitted a letter to me, which I will submit to all you and at the end of my testimony. And I just want to say 2 lines from the letter. He says that the law as it stands now protects level 1 sex offenders. And he says that they give out this information in New York City, in New York State. Why can we not do that in Massachusetts? And my question would be, why have we not done that in Massachusetts? So I do hope that this will be the year, the session, that we take action to protect children and we give access to parents, daycare providers, the Department of Early Education and Child Care, access to this information. And thank you.
Thank you. Any questions? Representative Bell?
Thank you, Representative. Quick question, while we're here, I thought I had been able to look that up in the past, and I'm on my city's sex offenders and follow the mass, and I'm seeing a whole list of addresses and people. Is that something else? Is that?
So yes, so right now you have access to level 2 and level 3 sex offenders online. Only level 2 sex offenders that I think were classified after July 2013. A certain date. The others you cannot have access to. No one has access to level 1 sex offender information except a handful of law enforcement agencies, police departments, but they cannot give anyone that information. And even the Department of Early Education and Child Care does not have access to that information.
So 2 and 3. We have access to.
3 and 2 that were classified after, I think it's July 2013, but I'm not positive on the date.
Thank you. I just wanted to clarify.
Just to check in on your statement, early education care has no access to that information. Early education care has access to entire criminal record directly. So they see everything.
Well, if you talk to Early Education and Care, and this came out during this case in 2012, they do not have access to level 1 sex offender information. You can verify that with them, but when I filed this, they were supportive of it because they want access to it. Maybe that's something we need to verify, but that is my understanding, and I do believe that that is correct.
I'm not sure what their level of access through SOAR is, but they do have 100% access even to sealed criminal records.
I will verify that with them. They have stated that they do not have access to this information.
Yeah, I think you might want to take a look at that. Thank you. Any questions? Gary,
Okay, thank you.
Dr. Raymond Knight.
Representative Cronin, Senator Brownsberger. My name is Ray Knight. I'm from Brandeis University. I'm testifying in support of 3068. This bill really has two parts. The first part, which is sections 1 through 5, deal with the reporting to lawmakers and to the community about what SORB has been doing annually. These data are important information that should be tracked anyway by the SORB. Because it's about documenting their decisions and identifying any trends and classification that vary over the years. Because of the great importance of the work of identifying dangerousness, such information is critical for public safety evaluation and for dissemination to all who are concerned about public safety. The second component is Section 6, which would require the SORB to quantify its tiering criteria, so that moving forward, they might be able to determine the reliability and validity of their current processes. I've been teaching psychometrics for 40 years, and I've been doing research in sexual aggression for longer than that. I also have created a lot of instruments that assess sexual dangerousness. I can state with an extremely high degree of certainty that fellow research scientists working in the area of testing and assessment would all agree that an instrument that has not been assessed either for reliability or validity has no evidence of any utility and may be working no better than chance. I just give a cautionary tale. Recently, we've evaluated the SORNA, the Sex Offender Registration Notification Act criteria that the government thought had some predictive validity. What we found out is that it either predicts at chance level or it predicts backwards. That is, the people that they say are the most serious offenders or the most likely to recidivate end up being the people who are less, and vice versa. There are good reasons to believe that the SORB criteria might do no better than the SORNA criteria. Public safety will only be served by basing our decisions on empirically sound data. Unless the SORB is required to gather data necessary for monitoring and assessing their efficacy, and unless a thorough evaluation is done of the reliability and validity of their instrument and procedures, there is no scientifically valid evidence to support the utility of what they do, and public safety is likely being sacrificed. Thus, Section 6 is critically important and essential. Preferably, it would be something that would be done by an independent evaluator, although that's not stated in the bill. So I strongly support your support of this particular bill.
Thank you. Any questions? Thank you.
Hello, I'm happy to be here today. My name is Dr. Carol Ball. I'm a co-founder of New England Forensic Associates, which is an outpatient sex offender treatment program in Arlington. I'm here to talk a little bit in support of Bill 3066 and 3583, which relieves adolescents from being placed on the Sex Offender Registry Board. First of all, when we hear the word sex offender, we assume maybe that everybody is included as a rapist or a child molester. Well, that's just not the case. It's a very heterogeneous group these days. And the majority of our new patients coming into our treatment program are internet sex offenders. And they mainly have possession of commercially produced child pornography. So many of those are adolescents because, as we all know, they're surfing the web, they're curious, they're looking at adult regular pornography, and they can inadvertently get child pornography. Now, all of a sudden, they're charged with a felony. I want to tell you a little bit about Charlie, one of our recent cases. Charlie was 15 years old when he came into our facility to be evaluated. He was charged with a felony for possession of child pornography and was later found guilty. When we knew we were going to present here today, we asked the parents of Charlie if they would be willing to come forward and speak, but they were too frightened to do so because they don't want this knowledge as public. They don't want their neighbors knowing about it and whatever. So now Charlie is a registered sex offender. Here are some of the things that he cannot no longer do. He is excluded from any community activities. He was once volunteering in an agency. He can no longer do that. He's prevented from going to college. I think the last speaker just spoke about that. Colleges are not going to accept a registered sex offender. He's prevented from most jobs. He can't work, so he must live at home. He has no access to the internet, which does prevent him from having communication with his peers. That's their social network. He can no longer do that. So he cannot develop any healthy peer relationships. He lives in fear of others finding out about this. And his life has consisted of living with his family in their basement with no employment and no way of getting any schooling. This is his fate until he could somehow be removed from the registry. I think this is wrong. This unfairly victimizes adolescents who don't have the judgment to understand what they're doing when they start looking, mostly out of curiosity. Most of these internet offenders have not had any hands-on offenses. They are not pedophiles. They're just curious about pornography, or they may be addicted to pornography in general. So I hope that you will consider relieving adolescents from being on the registry. Thank you.
That's H3066. So there's two bills.
There's two bills. Yeah, they're about the same, really. 3066 and 3583.
Any questions? Thank you very much. Sally Cooley, Laurie Levy.
Hi, my name is Sally Galmy. Thank you for letting me come, Representative Cronin and Senator Brownsberger. I'm here in support of Bill 3583. Those of us that dedicate our lives to treatment for youthful offenders believe that rehabilitation translates into the reduction of risk. In support of that notion, we notice that the reduction in the recidivism rate currently is at an all-time low of 2.2%, which that is to say almost 90% of adolescents that were adjudicated for sexual offense do not recidivate or reoffend within 5 years. We know and we assess risk based on such factors as the sanctions that are placed on them, completion of therapeutic treatment. In a recent study by Elizabeth Letourneau and Andrew Harris et al., the notion that children compelled to register, in fact, served to fundamentally increase risk of long-term harm to themselves. The premise and support of registration or notification is that any harmful consequences are outweighed by the potential for public safety. That premise is in fact flawed. This study supported that not only do youth offenders desist, but the risk of engaging in behaviors that render them at substantially higher risk of failure to thrive, failure to engage in developing the sense of self, strengthened by engaging and benefiting from a society that embraces healing and transformation. The risk these youth face while being registered include, but are not limited to, substantially more significant and an increased risk of suicidality and sexual victimization. We know that treatment is successful. The youth we serve come to us in greater need than I've witnessed in 20 years. The youth that we work with have experienced trauma, suffer from mental illness, and too often DCF is their only guardian. We assess risk based on the adolescent's history, we learn their stories, and we bring them hope. We treat the child of our society, those that too often have been abused by trusted adults in their lives. These adolescents come to us riddled with shame, and we know all too well that adult prisons are rife with adults laden in shame and rendered helpless, hopeless, and too often violent. That is the risk for public safety. We have learned that shame shuts down and prevents productive thought and speech. Full participation in life, pleasure, healthy self-esteem are counteracted by current shame states. And what does registration do in this society? It increases shame and limits the child's ability to go forth in their life. I worked with one young man when he was leaving treatment. He said to me, I feel like I'm walking out with this big sign on my back, and I'm not going to be able to engage in the things that you've all taught us are what's going to increase our sense of self. He wasn't going to be able to hang out with his friends. He was going to be registered. We hear about kids not being able to go to college. And I think that for him, that has lasted the 25 years I've been in this work. And my concern that kids are going to have to continue to be registered, and we now see the effects of that registration on them.
Thank you.
Hi, Madam Chair, Mr. Chair, and members of the committee. My name is Larnie Levy. I am a director at the Committee for Public Counsel Services, and I've worked in the area of sex offender litigation and oversight for probably about 15 years now. Before I begin on the issue of right to counsel at SORB hearings, I wanted to just briefly respond to something that Rep. O'Connell said about placing level 1 low-risk individuals on the allowing access to the public for low-risk level 1 offenders. And I suggest that the focus should really be on the Sex Offender Registry Board's process of registering people. If they get it wrong, where they have classified somebody as a level 1 offender who actually is not low risk, I would ask the legislature to look at how the SORB renders these classifications. And I think that's a really good example of what Dr. Knight was saying, that it's not empirically based. And that's a real problem. What I'm here to testify about is in opposition to House Bills 2300 and 3501, which would abolish the right to counsel for poor people who appear before the SORB. And there are two major problems with this bill. One is constitutional, and the other is practical, kind of common sense. Constitutionally, appointment of counsel for the poor is a critical due process protection under Article 12 of the Mass Declaration of Rights. Due process, as we all know, means a fair hearing, and a person who can't read or understand the 40 pages of SORB regulations or the 38 SORB factors or the scientific articles underlying these factors, who doesn't understand what evaluative reports and empirically based risk assessment instruments are, simply can't have a fair hearing. And given the SJC's recent decision raising the burden of proof from preponderance to clear and convincing evidence, the constitutional basis for appointment of counsel is stronger than ever. As a practical matter, when individuals don't have counsel, they go pro se. They often don't know what's going on at the hearing. They don't know how to introduce evidence. They don't know what evidence to introduce. And sometimes they don't even really know what's happening to them. And we've seen this. When the case would then go to Superior Court for review, for the Superior Court to look at the administrative hearing, the Superior Court will look at the record, see that the individual, there were violations of his fair trial rights, and then they're going to remand the case to the SORB. So what you're creating is then the SORB's going to get the case again. They're going to have to expend time and resources to retry the case, and they're going to be inundated with hearings, and it's not a good use of their time and resources either. When a case does arrive in Superior Court, the Superior Court, if the person is not represented, the Superior Court justices will always appoint counsel because they don't want clients to be unrepresented. It's too difficult for them and takes up too much time. What I would encourage the committee to do in conclusion is to put support behind House Bill 2324, which is an act amending the sex offender registry statute to require immediate registration of sex offenders at local police departments. The reason being, if we have pro se litigants, there's overclassification, it's going to cause more level 2 and level 3 sex offenders to have to register at the police stations. The police stations are already overburdened. In Area A1 in Boston, the police are turning people away. They're not registering people because they don't have the capacity, and they're giving them dates to come back and register. And so to avoid that, H2324 would allow people to register at their local police departments, at Dudley, at Roxbury, rather than having to come to Area A1 and get turned away and then get charged with failure to register if they miss the return date. I'd be happy to provide more information about that to the committee later. There were several people who were not able to come today. Their testimony has been submitted to the committee. One is Fred Smith, a retired program director from the St. Francis House, and both he and Andrea Casanova are writing in support of House Bills 3066 and 3583. Fred Smith, in his testimony that you now have, profiles some clients he had who came from suburban middle class backgrounds whose lives were essentially destroyed by having to register for stat rape convictions for consensual relationships with underage girlfriends, and resulted in substance abuse, unemployment, and homelessness. And Andrea Casanova, you may know, of the Alley Foundation. That foundation was created in memory of her daughter, who was murdered by a repeat sex offender. The offender was in the community as a result of loopholes in the law. He was untreated and unsupervised, and Ms. Casanova urges this committee to consider evidence-based research in differentiating adult sex offenders from adolescents and children. And then finally, you will be receiving in the next 2 weeks letters from 3 of the foremost experts in the country on juveniles, and that would be Dr. Robert Kinscherf, Dr. Frank D. Cataldo, and Dr. Elizabeth Letourneau from Johns Hopkins. Thank you very much.
Thank you. Representative Tucker?
Thank you. If I may ask a question on 3583. What I'm not going to ask you about is public safety and the shame and emotion that victims feel. Put that aside for another time. My question is, though, is there any concern, given your 20-plus years of experience, that we're making this a function of age rather than a function of offense? When I read the plain language of this, it talks about making juveniles exempt from this without regard to the sex offense or the sexual predator status. It's simply a function of age. Is that a concern to you at all?
I'm not sure that I understand the question, but I think it's in...
I can boil it down for you.
Okay.
This bill would exempt somebody because of their age, not because of what they've done. Does that cause any concern?
No. I think that, and that's what I'm trying to say. I think there's a fundamental difference. I think we know how to treat adolescents. We see in our work that these kids don't go on to reoffend. And we also don't even diagnose a child as a pedophile. We know our treatment works. We know how to do it. So I think it is significant. We know maturation is significantly different for children and adults. So I think that's an important piece that needs to be looked at. We can't assume kids are little adults. They're not. Their presentation and what goes into their offending is significantly different, and we know how to treat that.
Thank you, appreciate it. Thank you.
Thomas Kenny?
Good afternoon, ladies, gentlemen of the panel. My name is Thomas Kinney. I live in Hampshire County, Massachusetts, western part of the state, where I own a house together with my partner. It's an investment property. We rent the other 2 units to 2 other tenants. I always tell my former tenants that my current tenants and my former tenants that I am a sex offender. That has worked out extremely well. It's a face-to-face value. They respect me for that, and we have no problems. I'm here to speak in favor of Bill 3066, Act relative to juveniles accused of sexual offenses. I'm 42 years old today. I'm on the sex offender registry for crimes I committed when I was 14 and 15 years old against children. I was caught. I was also turned in by my mother. I was imprisoned and adjudicated delinquent, committed to DYS, Department of Youth Services, when I was 15 years old, December 2nd of 1990. I spent 10 years in Department of Youth Services. I was 6 months with a foster family. It was supervised foster family. This was approximately when I was 18 years old. By the time I was around 16, 17, being a kid, I was too stubborn to realize that through my treatment and everything else, I did terrible harm to the children that I sexually abused. Especially the first child I did, it was terrible sex offense. That's one that really sticks in my memory. That's one that keeps me on the straight and narrow today. I always bring that face back to imagination whenever something comes up, whenever I think about screwing up, which hasn't been, and hopefully will never be. Hopefully I can keep on the straight and narrow. To this day, I live with the fact that I can't change nothing. I can't do anything that I did to these kids. Nothing's gonna change. It's there, I did it, I claim responsibility for that. The realization of sadness was the key factor in realizing that, like, just doing the treatment, understanding what I did, where I did it, how I did it. And that's the main reason why I haven't reoffended, through the treatment and understanding what I did. Self-realization was also the beginning of my complicated journey of dealing with being gay. That don't change. I'm gay today, I have a gay partner, and I'm proud to say that. In the past, I wouldn't have been. And I'm dealing with that along with registration. After turning 18, I was transferred to adult jail, Plymouth County Correctional Facility. I was there for 30 days. There was an attempt taken on my life while I was there. I know today that I'm not the person that I was back then. I done harm, yes, and I'm changing that now. I changed that through treatment. I'm a different person today. Luckily, I can find work. I have dealt with some harassment since I've been out, from when we first moved to Ware. And a drunk lady showed up at the house, said, "I know you, I know what you're about." She had her two friends come in, 2 men try to enter the house, try to attack me and my partner, and I don't want to see that. That's all because I'm on the registration right now. And I face that as a daily basis, even with my work today. Someone could find out and I'm done. Thank you.
Thank you very much for sharing your story. I'm sure it was not easy for you to discuss, so we appreciate you doing that. Any questions? Any questions? Thank you very much.
Thank you.
Tyler Fox.
Thank you. I apologize for not wearing a jacket. It's hot in here. In fact, I'm going to roll up my sleeves. My name is Tyler Fox. I'm an attorney in Cambridge. I'm here to discuss House number 2289 and, in fact, to oppose it in the form that it's written. You probably don't know me, but I'm a civil rights attorney. I've been an attorney for almost 40 years. I'm a licensed independent clinical social worker. I practiced as a psychotherapist for a number of years. I practiced as a criminal defense attorney, represented juvenile offenders, and for the last 20 or so years, I've represented the victims of sexual harassment and sexual assault, both at the workplace and other places. Over the last 5 or 6 years, I've gotten an incredibly increased volume of cases involving sexual assaults by doctors. With that preface, the reason that I oppose House 2289 is for 2 basic reasons. The first reason, which is a little bit of a lesser reason, is, as one of the representatives pointed out, in my opinion, this bill almost invites, if a doctor is criminally charged, it almost invites expert testimony or testimony by his or her behalf that that the representation that they made regarding any sexual assault or sexual contact with a person was made for a bona fide medical purpose. More importantly, in my experience, the overwhelmingly vast majority of cases involving sexual assaults by doctors do not involve at all any representation whatsoever about what they're going to do. The sexual assaults often happen while the patient is unconscious. Even the ones that they're conscious, the doctors almost never say, this is what I'm going to do, or try and provide any sort of reason for doing it. So as a result, this bill, while it appears simple and common sense that it would achieve the purpose for which it's intended to criminalize sexual assault behavior by doctors, it will not do that at all. In fact, it's my understanding that Representative Hogan brought this bill forward in relation to a series of crimes by a serial sexual predator who was a fertility doctor in Massachusetts, Dr. Hardy, and I represented several of the victims. We attempted to get the prosecution of the Dr. Hardy. And in those cases, we were told that because of case law that's about 20 years old, that he could not be, about 60 years old, that he could not be prosecuted. There was no discussion about whether any false representation was made. I was told, and it's my understanding, that the Commonwealth does not prosecute cases of sexual assault by doctors because the consent is implied. It has nothing to do with whether or not the doctor makes any sort of representation whatsoever. So I would urge the Joint Committee here, and thank you for the opportunity to speak before you, both chairs and members of the committee, to really scrutinize this bill closely, not to report it out as it is, to either send it back to conference to have more discussion with people like District Attorney Marion Ryan, who I've had discussions with about this bill, with Representative Hogan and others, because this essentially not only gives a potential green light to doctors who want to sexually assault by allowing them to rely by saying something about what they're going to do and then attempting to rely on it in court, but in fact, you all know the difficulty more than me of how long it takes a bill to come forward, and I think it's likely to be a very long time if this bill passes, especially if people think that it stops behavior that in fact it won't, that the prosecutions are not going to happen, and it's going to be a long time before we are able to prosecute doctors for sexual assault.
Thank you very much. Any questions?
No.
Thank you very much, sir. Tamara Sobel. This is a panel.
She wasn't able to come. I'm very sorry. I'm going to try and cover everything. Hi, thank you for the opportunity to speak today. I'm Tamara Sobel with Media Literacy Now. We are a nonprofit organization focused on promoting media literacy education for every student. I'm here in support of House 948, the sexting bill. I'll just refer to it as that. We heard earlier a lot of the factual testimony on what a problem sexting has become. I'll give you a little bit of the statistics, which we may have heard already, but close to 25% of high school age students have been involved in sending nude or semi-nude pictures. 15% of teens who have sent those images send them to people they've never even met in real life. 61% of all teens who have sent these kind of images said they were pressured to do so. Many teens who send them are afraid of the results afterward. They feel embarrassed, they feel shame. And many, many teens just don't understand that there are serious consequences for doing something that seems fun, silly, flirtatious, whatever they're thinking at the moment. I like the a representative who said their minds are not fully cooked. So This is a bill that seeks to decriminalize some of those behaviors, but we're here to stress the importance of media literacy and digital citizenship education. And there are now 10 bills at least going forward in this body that are really promoting what we need to do now, which is to update education for this century, which is what media literacy does. Media literacy is also combined with the concept of digital citizenship, meaning teaching students what they are doing when they're on the media, when they're on their devices, and what are the consequences of those behaviors. Kids are very comfortable with their devices, with the media, but that doesn't mean they're very savvy about all that they're doing and the consequences for that. This bill does include a media literacy provision. We are hoping that that will be successful. Media literacy works. Digital citizenship education works. I have some anecdotal stories here. One school administrator said once he implemented an evidence-based digital citizenship curricula, there were actually zero, but by the third year of that program, there were actually 0 incidents of cyberbullying and sexting reported. 0. That's a huge, dramatic outcome. We're very fortunate in our state, and I wish she was here today. Elizabeth Englander could not make it, with the Massachusetts Aggression Reduction Center at Bridgewater State. They have been studying sexting, and they have created curricula that is extremely helpful, that has been used in over 400 schools across the Commonwealth. She is very willing to work on curricula with this, whether it's in this bill specifically, working with law enforcement, but there is very effective curricula out there. It is evidence-based and it shows results. We hope that this bill will be passed with the media literacy and digital citizenship component. We'd like it to be stressed more. The prevention part of this, we feel, needs to be stressed more in the bill, but we are very happy that media literacy is going to be hopefully recognized as part of preventing these terrible outcomes with sexting and other cyber situations. Thank you.
Thank you very much. Any questions?
Thanks.
Thank you very much. Jim Dawkins?
We're trying to get her right now.
Okay, sure. Is there anyone else here who wants to testify who may or may not have signed up? What's your name, sir?
Terrence Nunez.
Okay, if you want to come forward. Sure.
Thank you.
Good afternoon. My name is Terrence Noonan, and I just want to take a very short moment and show my support for 3068 and 3583. 3068, as Dr. Knight was speaking about, goes to data gathering and validity of tools that hopefully this SOAR will use. As somebody who works with both victims as well as perpetrators of sex crimes, there's nothing more frustrating than having to deal with a methodological system that has no validity, and the SOAR has 0 validity. During the one public hearing at which the new regulations were being promulgated, all 3 of the experts who testified, including Dr. Knight, said that this system was actually making it worse. And what that means is that public safety is undermined. That means that we can't, as Judge Holgian noted, you can't tell the difference between a 3 and a 2 and a 2 and a 1. That's not public safety. That's public guessing, and that's a waste of money. And the next thing I would note is that I think the entire system is unconstitutional. I don't think it passes a rational basis because there is no validity to it. They don't have any recidivism studies. They don't have any recidivism data. So when you look at Goodridge and you see that that didn't pass a rational basis test, then you look at the SOAR and you say, how can this possibly pass constitutional muster when they're here to protect the public, and after 20 years we don't have any data that shows that that's in fact what they're doing. So going a little bit short of declaring it unconstitutional, which the courts seem to be moving towards, as Justice Kant has consistently effaced the arrogation of power by the SOAR, increasing the level from preponderance to clear and convincing, guaranteeing counsel, making sure that the people can have experts. We're moving towards finding that in fact this is an infringement that's unconstitutional, not rationally based. Short of that, I would say please support 3068 because we need to have empirical instruments that can actually make a better judgment than a coin flip, which is all we have right now. The next one is 3583, which removes juveniles from the registry. This is by including juveniles on the registry, it's iatrogenic. We are creating the exact circumstances that we're hoping to prevent by putting them on the registry. We're guaranteeing a permanent criminal underclass of juvenile offenders for at least 20 years, if not longer. They can't find housing, they can't find work, they can't travel, they cannot associate, there's nothing pro-social, and that lasts at least 20 years, if not longer, depending on when their offense was. So I would urge people to please look at this and look at the science. Dr. Letourneau, Dr. Hansen, look at the science and see the damage that we're doing. These are decisions that were made by juveniles. As Justice Kagan has noted, and Sotomayor, these are the people who are most amenable to treatment and most amenable to change. So please remove them from the registry. Thank you.
Thank you very much. Is there anyone else here? Kim Dawkins, she must have left. Okay. Anyone else? Last call? Okay. We move to close the hearing.
So